Marathon. Now, the 34 judges who were elevated to the Court of Appeal and various divisions of the High Court were sworn in at State House, Nairobi, Friday, with President Uhuru Kenyatta urging them to serve Kenyans with unfailing integrity and diligence. President Kenyatta said he would not turn a blind eye to reports of state organs in the performance of duty by quote-unquote choosing the right over the convenient. Our senior political affairs reporter, Politics With Ben Kitili, has that details for us.
After more than 2 years since the nomination and the bitter fallout between President Uhuru Kenyatta and Chief Justice Emeritus David Maraga, 34 out of the 40 judges converged at State House, Nairobi to take oath of office. The swearing-in ceremony was attended by, among others, President Uhuru Kenyatta. Chief Justice Martha Koome and President of the Court of Appeal, Justice Daniel Musinga, were present.
I, Msaga, am Raphael Mbogoli.
I, Ngoge Grace Mumbi, a judge of the Court of Appeal.
7 of the judges were sworn in to serve in the Court of Appeal, 9 to serve in the Employment and Labour Relations Court, while 18 took oath of office to serve in the Environment and Lands Court. And here was the President's advice.
Serve the people of Kenya with unfailing integrity and commitment.
President Kenyatta disobeyed 2 court orders to have these judges appointed. And when he finally gazetted the appointment Thursday, he rejected 6 judges from the JSC list. The move caused an uproar and condemnation from the legal fraternity, but it would appear the president is unbowed.
I too took an oath to both the letter and the spirit of the law, and it is not open to me to turn a blind eye to reports of our state organs. As long as I serve as president, I will choose the right over the convenient, I will choose the hard over the easy, and I am not doing this for myself, but for the people of Kenya and for posterity.
Though present, it was curious that Chief Justice Martha Koome was never invited to make remarks. The president reminded the new judges and those promoted on demands for their new offices.
Many new burdens will be placed on your shoulders. The public expectations on you will be very high, and obstacles will be thrown along your path.
The president's brief speech lasted 2.5 minutes.
You are the bastions of justice, defenders of liberty, instruments of law and order, guardians of the rule of law, and the embodiment of the hopes and dreams of our people.
The president called on state officers to collectively serve the people and deliver on their hopes and dreams. Patrick Amimo, KTN News.
All right, that was on Friday in studio with me, like I had said earlier, with me, political risk analyst Dismas Mokua, governance expert Charles Kipkulei, lawyer Ishmael Nyaribo, and joining us by way of Zoom is lawyer and political strategist Kipchumba Karori. Let me begin with you, Bonawakili Karori. Happy birthday to you, first of all. We celebrate you here on the show. But a lot has been happening in the last 4 or so days. The president swearing in the 34 judges, coming hot on the heels of him, appointing 34 instead of 40 of those judges. He said on Friday at State House, Nairobi, that he was choosing the right over the convenience, the easy, the hard over the easy, that he was doing this for Kenya, for posterity. What are your thoughts? Open this for us today.
Thank you, Ben. Thank you, Ben. I think we, first of all, must condemn the usurpation of the constitutional order by the president. In essence, that, Ben, the presidential opinion cannot supersede a court order. That is where we must begin from. That a president must at all times be and operate by the rule of law as espoused by the Constitution. If we were to go to all the articles, starting from Article 10, that gives us the key values and the key tenets of this Constitution, like the principles of our Constitution, therein lies something like the issue of good governance, transparency, public participation, and all these things. When a president refuses to appoint or swear in the 6 judges, where has he gotten this extra power? Are we saying that the president can, by dint of his opinion, amend the Constitution? Because if we go by what Uhuru Kenyatta did on Thursday, then, Ben, we can argue that using these powers that are not discretionary, a Chief Justice can refuse to swear in a president. Look, for example, if today a president is elected, IBC gives the president the certificate of valid election, the Chief Justice has no other role but to swear him in. If we go to Article 166 and 172, Subarticle 1, you realize that this is one of those powers that the president has, which are ceremonial. This is when he is acting as the head of state. The same way when the Queen is opening the Parliament, or the British Parliament, he has no discretion. He has to do it. And we must develop a contradistinction between the powers a president exercises as the head of state and the powers he exercises as the head of government. The latter and the former have a difference because one is executive in nature. The other one is done in order to knit the fabric of the nation. And the failure which we must now discuss on this constitution is its inability to protect itself from the shackles of the overbearing executive. If this is to be left as is, the danger is this, Ben. A president coming tomorrow might want to wade in and expand his power in the name of protecting the posterity. All the protections that the posterity have been given in the Constitution. When you read from the preamble all the way to Article 249, it says that these independent commissions have a role to play in terms of enhancing constitutionalism, in terms of enhancing observance of rule of law and this constitution. So therefore, Uhuru Kenyatta cannot claim more power and protection to the constitution than any other organ. He himself is a beneficiary of secondary power. The only people who have sovereign power are the people. Uhuru Kenyatta cannot correct the law, which is the
that
supreme
thought
law.
there. All right, let me hear the rest of the gentlemen in studio. Bwana Wakili, here is a question that a lot of people have been asking the last 2 or 3 days. Can the president cherry pick who to appoint once he's handed over the list by the Judicial Service Commission?
Clearly, Ben, the answer is no. He cannot decide that I will pick 3 and leave 4, or pick 5 and leave 2. But when you look at the word cherry pick and where it started, you will find therein lies the secret. The issue is, actually, if you use the ordinary English language, cherry pick means you're really picking the best and leaving the worst. Who is Odunga? Who is Evans Makori? Who is Justice Mshelule? What kind of careers have they built? Who is Justice Joel Ngugi? These are the best, if you ask me. But they have been left out.
In my understanding, in my very lay understanding, is that the JSC has already picked the best.
Correct. And can the president, therefore, decide I would? No, he cannot. But there is a history of doing that, Ben, that in 2014 as well, there were about 25 judges, and he did not pick all of them. So I'm still wondering when he will actually come back on air and say, okay, again, I'm sharing the other 6. This he will have to do. I keep asking myself, is obedience to the Constitution of Kenya an art or a science? I mean, is it technical? Is there something that is not being done by the men around the president so that he makes a decision that goes against the law? When you talk about the president, Uhuru Kenyatta, he moves in a certain way. That's how leadership and power works. He moves in a certain way. He cannot just wake up and say, I'm going to have a drink downstairs, or I'm going to Hurlingham and I want to go and sit there and have a meeting. The people who move with the president, Ben, are a large number of people, the advisors, the technocrats, the people who prepare his talk next time, the speech, and all that. So if you want to blame one individual and say, he has done something, for me, you must tell me who are these sitting around the president, telling him you can actually swear in 34 and not the 6. Now before you take the mic again, how is it possible that 34 judges went to be sworn in against an order of their court? I mean, the court says they will be sworn in 41. One has died. How is it that the same judges disregarded the court order and allowed the president to swear them in? Therein lies the secret.
The Chief Justice was sitting there.
Well, the Chief Justice, again, must do his role as a Chief Justice. And you'll notice that it is in 2019 when actually the former Chief Justice, through the JSC, recommended the names to the president. So, Ben, unless we want to make everything political, the way I see it, when you talk of the president obeying or not obeying the orders and the Constitution, it relates to the presidency. Mm-hmm. That includes the President of the Republic, that includes the Deputy President of the Republic, and all the people who are in charge of making sure that the President's office is delivering service. Okay.
Charles, we have been talking about tough wars between the executive and judiciary during the reign of Chief Justice Emeritus David Maraga. Many Kenyans thought that those are over. But in the last 1 week alone, we have seen the president, dress down the judiciary, telling them that they will have to start, paying for consequences of their choices. Then we have seen the president appoint some judges, leave out others, 6 of them, then going ahead and swearing them against a court order. Where does this leave the relationship between the two arms of government?
Well, Ben, thank you first for having me today. And as you rightly put it, I think what we are witnessing is a carryover from the reign or the tenure of former Chief Justice David Maraga, who came into the judiciary with a very strong reformist agenda in the judiciary. And naturally, this attracted resistance, especially from the executive arm of government, which felt that sometimes a ruling can only be good if it is favorable, which then goes against the principles of law that ideally, what is right is not what is favorable, because if you speak about favor, it is something that is good probably to a small parochial interest, not the general good. So what we are witnessing right now is a carryover from that tenure of former Chief Justice David Maraga, and it is now coming to the tenure of Chief Justice Martha Koome. And where we are now, we are seeing a problem where initially we used to witness intra-arm conflict. We could see probably a political contest that is limited to parliament alone. Probably there are some squabbles within the executive. But what we are seeing right now is that it's one arm of government going against another. And you see in the whole architecture of government, the three arms are supposed to exist in complementarity and with a balance that has been created by the Constitution. So where this leaves, the situation that we are witnessing now, where it leaves Kenya and even it leaves our country is that first, it puts into a lot of, I will say, uncertainty. The question of rule of law, the question of access to justice, because down the path, we'll see that because of all this tussle that we are seeing, there are budget cuts. There is the question of delayed access to justice, some delayed buildings which were done across the country so that
in all of it. What do you think the president is trying to achieve?
Well, at face value, what we are seeing is that it's a political contest that has been taken, that should not happen at that level. What the president seemed to be working towards is that, you see, this, for us to understand this best, let us start from where we've come. We have three arms of government.
Yes.
Parliament seems to have been emasculated. They do not have a voice in everything that is happening. In fact, if you ask me, the reason why we are here today is because Parliament, the voice of Parliament, which was supposed to check the executive, even when it is overbearing towards the other arms, is lost. So first, Parliament has been emasculated, and then now they're going for the judiciary. Okay. So where what the president really wants to achieve, we can get it from the last speech he made in Kisumu during Madaraka Day, where he said that we have tested the limits of our constitutionalism. I do not know. I have a problem and a serious quarrel with that statement, because then it will ask us what is the quality of the advice in the president's court. What is the issue that whoever is advising our president, what do they want him to communicate and to what end? Because they are misportraying him as an executive who is out to achieve an individual parochial agenda and not the national and the greater good. So for me, I think what we are seeing, the optics are not good, and what we require right now is serious relationship building between the arms of government. But before that is done, there has to be a recognition and a serious mutual respect of each other, because that is the only way we can remain stable as a country.
All right. Dismas, the president has been criticized the last couple of days for all manner of things, but you do not think that he should bear all that blame, do you?
Well, you know, it's become, the last couple of months, the last 6 months, in Kenya, it's become very fashionable to go to the top of Mount Kenya or Kilimanjaro and criticize President Kenyatta. for all manner of ills. And I think there's the people who have created a bandwagon that if you want to be seen solid in the eyes of a public media or even on social media, at every instance, you must criticize the president. But let's go back to the beginning. From the time President Kenyatta and his Deputy William took office about 8 years ago, the economy has been bleeding. The normal Kenyan is not breathing because there is a huge burden on their neck occasioned by impunity, mediocrity, and corruption. If you meet Mora or Wanjiro or Nekesa or Chebet, they'll say this administration has done a lousy job. But when you come to the issue of Article 166, and I've had a moment to reflect and have conversations with senior members of both the bar and the bench, and they say that if the drafters of the Constitution intended that President Kenyatta or the President of the Republic of Kenya role in this accumulated matter was merely ceremonial, then what they would have done, they should have said that the Judicial Service Commission shall do the interviews, and when they have a short list, they give it to the chairman of the Judicial Service Commission or the Chief Justice to gazette. There is no way an appointing authority can be merely ceremonial. And you know why the president sits? And if you go through this constitution, you know, reference to Chapter 6, Article 10, and then also from Article 131, 132, and 133, the president is supposed to defend our national and public interests. What happens?
Could you define that for us now? Let me be the devil's advocate. In this case of the 40 judges, is the one who has since passed on. How is the president defending our national integrity?
Okay, you see now again, we'll be going to a place where we could easily be accused of libel or slander. I'll not mention the names, but I'll just give a scenario. Right. And it's very clear that from the time President Kenyatta took office, the people in his court, people who are advising him, have been doing a very lousy jobs. He's done so many errors that one would never think during the administration of President Moi or even President Kenyatta. Right. I think the quality of advice he's been receiving is horrible. Now, assuming that the Judicial Service Commission has given you a list of 10 names, and the people within the commission, for some reason, they've done a lousy job, and in the names you've been given, 10 of them appear to be agents of other foreign powers. Maybe one is a spy from another country, one could be an agent of Al-Shabaab. As a president, when you have that information where you are seated, and you see the president sits in a very unique position, is probably the only person in Kenya today who would tell Loanyaribo what he had for breakfast this morning because he's got access to a body of information. Now, if it comes to the president's knowledge, there are persons you are about to appoint to the Court of Appeal or the High Court, in fact, criminals, there's some information which was not available to the Judicial Service Commission. Okay. Do you go ahead? And there's also another issue that nothing would have been so easy for the drafters to say that, Mr. President, because we want to create 3 silos, you'll also be watching news to understand who's been appointed to these courts. That's okay. Number one. Well said. The number 2, the judges who are appointed and who've taken office, those are 34 judges. And if you go with the bare minimum of the qualifications they need of 10 years, so during that meeting, you had a legal knowledge or experience or academia all combined of about 340 years. So can someone actually suggest that these 340 years of lawyers, right, judges, magistrates, all of them participated in an illegality? That the president participated in an illegality, the judges participated in an illegality, and the Chief Justice witnessed an illegality. All right.
I want to go to Wakili Karori, but before I do that, the president has representatives sitting in the Judicial Service Commission. Why would he be surprised by this new information about Judge A or Judge X? Now,
when you look at the people at State House and at the Judicial Service Commission, it's very clear, even to an ordinary person, that they have successfully failed in delivery of their mandate. There's no doubt about it, because, I mean, how many of these presidential actions have been declared null and void? People have easily lost count. And then also there's another thing that people are saying, that maybe the judges omitted is because they've been making unfavorable ruling to the president. But one of the judges who was appointed to the Court of Appeal, Justice Lesit, a few days ago came up with a ruling which quashed most of the appointments made by the president. So claiming that again it's because of their rulings that the president is cherry-picking, in my view, it doesn't stand.
Ben, the question you've asked Dismas, and the answer is simple. The decision by the JSC to hand over a certain name and leave another one is based on a vote. So even if the president has representatives down there in the JSC, finally after the interviews, after collating the information and looking who has gotten what, it is by a vote that yes, we agree this particular individual has made it or not, both based on the marks and based on the general perception. So it is possible that another name, which may have been rejected at the JSC level, is actually forwarded.
All right. Kipchumba, what do you think about Dismas's remarks here?
I think, Ben, we need to go back to the case filed by Adrian Kamotho Njenga versus the Attorney General. And also we go through the case filed by the Law Society of Kenya versus the Attorney General. When the three-bench court was faced with the question Dismas is asking, the answer was simple. When you go to Article 10, there are three things that each institution must live by. The issue of public participation, integrity, good governance. JSC advertised for the position of judges. It shortlisted the names of the people who were to be interviewed. All state organs and the Kenyans of goodwill and any other person who had an issue with these people was invited to come and present before the JSC. When this opportunity was given, what did the NIS do? The NIS sent a letter saying they have an issue with 1 to 3 people. The problem lies therein, and the problem is one of this nature, Ben, that under Article 47 of our Constitution, you cannot just come and talk about things without taking into consideration the issue of fair administration of justice. You can't allege something about Kipchumba and not give me a chance to defend myself. And that goes to the root of this whole process. If NIS, and when you read the pleadings of the respondent in the cases, the thing that the Attorney General pleaded in court was that these people, we said they had a problem. But the question we need to ask is this. If the NIS had a problem with these people, why didn't they furnish it to the JSC? And further down the line, when you read the NIS Act, it says that the information that cannot be shared is only classified information. What is classified about the integrity of a judge? That is what we need to break down. The other question is this. A few days ago, Didmas Mokua argued here about that the role of parliament is merely ceremonial when it comes to BBI. You cannot now change when interpreting constitutional, textual, and doctrinal norms. We have to be consistent with whatever we are talking about. And when it comes to the issue of a president or the person occupying that office, their obedience of court orders is in furtherance of this nation as a democratic republic. It is not a political tool, but a constitutional order tool to bring and make Kenya governable going to the future. Then we were in such a place before 2017 where people lost hope of the court. The other question which Didmas Mokua must answer is this in finality. What happens tomorrow to litigants who will appear in a court where Odunga, Professor Ngugi, or the other judges are? We are putting these courts in a place where we don't want to go there. The other thing is, if NIS has issues with these judges, why don't they write to JSC so that we remove them through the constitutionally ordained process?
All right. All right. Before I come to you, let me, and I want to come to you, Charles. Dismas, what do you say to that? What happens tomorrow when they are, and Wanawakili will also indulge me on the same, the two judges, Justice George Odunga and, just an example, Odunga and Joel Ngugi and even Muchelule, they serve in the high courts. What happens tomorrow when litigants go before them? Now, yet the president hasn't given any reason why they did not meet the threshold.
Well, you know, we've been saying times are above number, that what the president has been lacking is solid advice. Now, the expectation is that the first thing you would have done, you will do tomorrow morning, is to send his memoranda of objection or petition, whatever it is, immediately to the Judicial Service Commission for them to carry their own investigations or maybe form a tribunal so that they can come into a conclusion. But as we've indicated, times are above number, that there's been impunity coming from the Jubilee administration. So they do not follow procedures, and it's because of this reason that we are in trouble. But for me, I would expect there are these judges, because of this pressure, if a matter is presented to them tomorrow, they actually go to their station heads and seek to take a break to give the opportunity for the president to express those reservations. I know it's important for the president to do this very fast, because if he doesn't do that, there's going to be a lot of character assassination. Because now most Kenyans are beginning to look at these judges who are left out and asking, what are the primary issues? What is going on? So the president would save them a character assassination by doing that. And then on the first issue, still, when you go to that Article 166, it talks about the appointing authority. Now, the question one may want to pose to lawyers or jurists or members of the bar or the bench is, now, since when does an appointing authority become ceremonial? And if the drafters of this constitution, who are actually lawyers... Well,
it's in the constitution.
Yeah, but I'm saying now, the drafters of the constitution, who are lawyers, why did they not say that because we fear there's going to be overreach from the president, the mandate of recruiting and nominating and gazetting judges will rest purely with the Judicial Service Commission? That would be the easiest thing, even from a layman's perspective.
Thank you for that. Charles, tell me this, and as you make your point, there has been an indication or suggestion that the president is against judges who have not been very kind to him. Justice George Odunga and Professor Joel Ngugi were part of the 5-judge bench that nullified the BBI. Is there such a narrative where some judges that have been seen to be activists and bringing some kind of judicial reforms that are don't augur very well with the executive and the president, that those ones are being, held down?
Yeah, well, thanks, Ben. I wanted to make a statement based on what this man has said on the issue of an appointing authority. I think sometimes you also need not to look at it in terms of like the president is the one who is the appointing authority in every scenario. Where we have, I think because of the architecture of the role of the president, is the head of government and also head of state. But I think the authority that appoints judges in our country, we all know, this power rests with the JSC. So I think with that clarity, then we will not be abusing this issue of referring to the president as the appointing authority. He's been given that position by virtue of his office as the president and head of state, head of government. But now to your issue that you've made, the question that you asked. I started by saying that I have a quarrel with the statement that the president said, that he referenced the issue of the election that was annulled in 2017, and now down to the issue of the BBI. You see, when such a statement is made at that level, it then creates that notion and a perception that there is a parochial interest that is being pursued and it is not the greater good, which is why I hold that, number one, within the council, the quarters that advise the president, there is need to look at what is the import of a statement once it goes out, and how do these relationships and the perceptions that are created, how do they augur well in terms of now the stability of the relationship between the three arms of government, and now we go forward as a country. So for me, we may not be in a position to say that the president has a bone to chew with particular judges based on the judgments that they have made. But you see, for the layman, if you come today and you see that the list of 6, amongst those who have been denied or who are rejected, there is Justice Ngugi, there is Justice Odunga, who have been outspoken very much on issues which seem to have been priority to the president and even to the administration, then that perception can be created. And sometimes in politics, perception informs reality. So in the minds of many, and in the absence of proper communication and proper management of the optics, especially the statecraft that has to deal with how the president addresses himself on some issues, then the perception has been created and it needs to be addressed. Because I saw even in the report that was done, when the Chief Justice was invited to State House and was not even given an opportunity to make an address, and later at night she released a statement trying to exonerate herself from the issues and even going further to push and asking the president to appoint the other 6, then it creates a perception as if it is one arm that is at war with not even one arm, it is an individual at war with a number of persons, of judicial officers who are in court. And particularly because if really there are serious integrity issues that affect, that have been labeled, that have brought against these judges, then the natural thing that should have been done, because this was done 2 years ago, and this information understandably should have been brought to the attention of the JSC and even the president 2 years ago. I join in the sentiments that within those 2 years, something should have been done to make sure that indeed, if there are serious integrity issues that have been labeled against these judges, then they should have been removed through a legal process, the tribunals. But you see now, if you come up to today and they are now just rejected without strong reasons, then the perception is created. And then that perception informs reality. And in the minds of many people, it will be seen as if the president has a particular bone to chew with specific judges in the court.
Ishmael, those judges continue to serve. They've never been removed. No charges have been leveled against them. What gives?
Ben, 3 limbs here. One, the good judges will go to the court tomorrow and this week and continue performing their functions. This is very clear, and it is out there in the Constitution. These judges, first and foremost, we do not know if they have anything, whether it's corruption-related, character, or impartiality, according to the Constitution. These are judges who have a high moral level, who have, impartial ability. These are competent judges. The only thing that has not been done to them is they have not been promoted. That is promotion. It's a personal matter. It's an HR matter, by the way, if you ask me. They were applying to go to the Court of Appeal from the High Court. So if they will sit tomorrow, Judge Odunga should sit and hear all the matters. And Kenya has a high literacy level, I think over 50–60% now. Kenyans are not stupid. That's why we have a high level of debate amongst lawyers and non-lawyers on the media, because they understand the basics. They all know that these judges may not be having any issue. So it's a question of promotion to the Court of Appeal. And that, to me, is honestly a personal matter between the judge and whatever the NIS or the president has thrown back to the JSC. Once that personal, small matter is resolved, these judges will go back and be promoted to the Court of Appeal, and they will be sworn in. And if not, then a tribunal must be formed to advise the president that since you have said that these particular individuals have an issue, you need to remove them through the normal, through the lawful process. Did the president actually victimize these judges because of the BBI? Again, Ben, the answer is no. A straightforward no, because they were recommended to the president. In 2019, there was no BBI court case, like which, Odunga and Musherule and Ngugi were deciding on. So now coming here to say, okay, fine, now probably the president has something personal with them, that actually is quite unfortunate. The truth is,
they were afforded to the president ages ago.
Yes.
But then the president has made the decision after the BBI rule.
But you remember, he refused to swear all of them in anyway. And he said that there were, I think, 5 or 6 whose report was not correct. So if he saw in the 34 in 2020, would we have claimed that Odunga and Ngugi and Musherule have been left out, and the rest, of course, because of the BBI? So I don't like a situation where Kenya is so smart, but they try to mix Maziwa Mala and Uji and put Githeri, and then, you don't put everything together like that. This particular leaving out the 6 is unfortunate. Every lawyer, every good-minded Kenyan thinks it is unfortunate. But we cannot just also cherry-pick in terms of ideas and conclude that the president has an issue with the 4. The president as a person probably has no issue at all. As I said, the people around the president, and that begins with the deputy president. Remember, they were in very good books years back, and I'm very sure these are the people who move around the president who must have advised him not to pick the 6. So these 6 should be taken back to the JSC, and then we hear a new date when he's supposed to.
The Chief Justice has said that, did urge the President to swear in those 6. I want us to talk about the Chief Justice very quickly and how she's coming out in our very formative days as the head of the Kenyan judiciary. So here's a question. Has the Chief Justice, Martha Koome, given in to the so-called judicial capture by the executive? Here's a question in the minds of Kenyans and legal experts alike, following President Kenyatta's decision to swear in the 34 of the 40 judges given the nod by the JSC. KTN News senior political reporter Maureen Mwangi highlights the hullabaloo following Kenyatta's move and explains why experts fear a judicial capture may be slowly taking shape towards his exit.
Caught in the judiciary executive grandstanding over President Uhuru Kenyatta's failure to appoint 40 judges nominated by the Judicial Service Commission, the JSC, in the recently concluded interviews to pick the country's Chief Justice, had a random question to its interviewees, among them Lady Justice Martha Koome.
I have faith. I'm a woman of faith. I believe I will be able to explain why I want to speak to His Excellency to have a meeting. And I believe he will give me, because it's not for myself, it's not for my sake as Martha.
2 weeks into Koome's swearing in as Chief Justice, President Kenyatta has acted in a Gazette notice, only appointing 34 of the 40 proposed judges, in a move widely criticized within legal and political circles, raising fresh queries on the future of the judiciary under Koome and its relationship with the increasingly hostile executive arm of government under President Kenyatta.
It has become a practice by the president, with the greatest respect to him, it has become a practice by him to continuously ignore, disobey court orders, and basically just practice impunity.
We avoid a situation where power has gotten into our hands and we start forgetting the Constitution. We need to respect the Constitution so that this country can move forward the way it should, governed by the rule of law, not by the rule of the jungle.
Prior to his retirement, former Chief Justice David Maraga on several occasions clashed with President Kenyatta, demanding that Kenyatta ought to have appointed all the 40 judges as nominated by the Judicial Service Commission, arguing that the head of state had no powers to veto the JSC nomination. A standoff that was characterized by heated Kenyatta-Maraga bitter exchanges, climaxed by radical budgetary cuts on the judiciary, which, coupled with the shortage of judicial staff, saw the Maraga administration close several courts.
Nobody can stop reggae.
And in the wake of recent High Court nullification of the Kenyatta-led Building Bridges Initiative referendum push, the judiciary, executive bad blood, is making a slow comeback, putting Koome right on the spotlight.
Can Kenya truly be a democracy if the people are denied the opportunity to express their sovereign and supreme choice at the ballot box on the basis of elevating technicalities over the overriding objectives of the law?
If there's one person in government who thinks that any of these judges that is not fit to serve as a judge, because those who are already serving in the High Court are judges, then let them present a petition.
The BBI appeal that also features President Kenyatta is already before the appellate court, whose president, Justice Daniel Musinga, is due to appoint a 7-judge bench to hear it. And with the high succession stakes in the appeal, the executive judiciary tug of war may be far from over. Muremi Mwangi, KTN News.
All right, we only have 7 minutes. Kipchumba Karori, very quickly, what is your view on the Chief Justice's performance in the wake of the events of the last few days, starting with Friday, when she was in State House? She did not speak. She later released a statement demanding or urging the president to swear in the 6 judges who were left out. And also, during the Baraka Day celebrations, the president also had some very strong words for the judiciary.
Ben Kitili, Ken Walibora, may the Lord rest his soul in a good place. He wrote a book known as Siku Njema. And in the Siku Njema, there is something we call in Swahili, Siku Njema huonekana asubuhi, huonekana mapema. If we were to judge the Chief Justice, Lady Martha Koome, from what she has done in the last 3 weeks, the judicial and the future of this country is in a bleak place. For a simple thing, Ben, Uhuru Kenyatta heads the executive arm of government. Martha Koome as the judiciary, when she bowed before Uhuru Kenyatta, that is where our problems began. Justice is about perception, Ben. Power and control of constitutional institutions is about perception. When she sat down in Kisumu when she was given the tank lashing by Uhuru Kenyatta, that is where the problem was. Maraga showed us that a functioning judiciary is a judiciary that stands its feet, is a judiciary that invokes the power, the residual power we have given them directly. That is the power. We need her to now settle in office and know that the judiciary faces continuous fights from the executive, because executive is in a continuous process of looking for power and trying to consolidate power. Most of the people who are implementing Constitution 2010 are people who came from the Kanu Nyayo Tingisha Kidole era, who believe in a system whereby the word of the executive or the sovereign is the word of everybody. So we need her to be strong. And there is a statement that she said in an interview that she will need 3 years to settle in office. That statement should be worrying Kenyan, because if you can settle for 3 years in an office that you will be there for 9 years, it shows that there are things that are not in order. And in finality, Ben, there is something that my senior Ishmael Nyaribo has said that cannot go uncontested. We must correct the record for the public. There is no law, known or otherwise, that allows the president to write a memo back to the JSC. When you read the architecture of Article 166 and you extrapolate all the way to 172, and you now tie it into 249, you realize that the president is duty bound. And we have 2 court orders which made 3 declarations in Adrian Kamodo and 4 in the LSK versus the AG.
All right.
The president has no reverse gear on the issue. Let me paint a picture to Kenyans as I live. If today the Speaker Muturi was to send a name of, let's say, Martha Koome, we have no remit in law that allows Uhuru to return a name. Once Parliament has done their function, Uhuru is just a ceremonial person in the tail end of the chain to make sure that the Chief Justice is sworn in, just the same way the Chief Justice is ceremonial as he or she swears in the President after the declaration.
All right, thank you.
Notwithstanding that if
Kipchumba.
the Chief Justice had taken a contrary opinion in a presidential election.
Thank you. Bonawakili, very
So
quickly.
let us avoid the...
Yes, yes. Let's hear from Wakili here.
You've asked about Martha Koome. I will leave that comment to lie. But you've asked about whether there are people who actually believe that when the president is swearing in judges, if they bend before him, it's a sign of subordination. I think on that one we need a completely different engineering in the mindset of our people. Much as there is parliament and there is the judiciary, and then here in between is the executive. Mr. Ben, the Constitution itself has put it in such a manner that there is one among all these arms of government who then carries the instruments. There is one who has to make the payments. Yes, under the Constitution, but you cannot feel bad that the law requires that you will go and carry up your Bible and swear that you will do everything in accordance with the Constitution before somebody.
All right.
Now, I think a lot of hate and gossip and I don't know how to call it is geared towards fashion and style, not the real content. Martha Koome had a duty.
Your thought on Martha Koome's response?
Yes, Martha Koome had a duty to go to the president to be sworn in and to bend before him. That's not an issue. It is not showing any insubordination. Now, Ben, in terms of whether she has succeeded or not, is it not so quick to judge Martha Koome? Because she was interviewed and she honestly confessed that the moment I take over as a CJ, I will do whatever it takes, including negotiating with the president or with the executive to understand what is the problem. So the fact that she was not given a chance to speak at State House, again, that's a whole other, different story.
All right.
So we cannot judge Martha Koome. And please, let's not use the Chief Justice Maraga or former Chief Justice Mutunga as the only a rule of measurement for Martha Koome. Lawyers are 18,000. I will tell you today, my brother here will give you an opinion, Karori will speak his opinion, and lawyers are 18,000. They will all give you different opinions. But in reality, Martha Koome is on her way to succeed if we give her the chance and allow her to.
Charles, 1 minute only. Give me your thoughts on Martha Koome.
I agree that it's a bit too early in the day to really put a strong verdict on the performance of Martha Koome as Chief Justice. However, she had an opportunity to really stand and have a very strong start to her tenure, because this issue of judges comes at the backdrop of court orders. So that one, we leave it to time, because even Chief Justice Maraga, I think many of us did not really consider him as a very strong Chief Justice until 2017. And then further, when he now became very bold, including talking about the issue of the dissolution of Parliament and being a very strong defender of the need for the independence of the judiciary. So for me, where Martha Koome finds herself is that she's in an opportunity of redemption. She has now to look at issues that bedevil the judiciary. If she can unlock the question of the radical reduction of the judiciary budgets and bring back the program of access to justice and infrastructure development, and particularly to unlock this issue of the 6 judges who are remaining, and then going forward on many other issues that will come, then we may have an opportunity to look into her differently, because a legacy is a verdict of history. You cannot judge somebody's legacy at the beginning of a term. It's only when you leave. And you know, it's like a football team. When you concede a goal in the first minute, probably there is panic in the bench and everywhere. So she has an opportunity to redeem herself, but that then calls for her to be really strong in terms of defending the independence of the judiciary and protecting the judges from onslaughts, particularly from the executive.
Have the final word on this. How big of a job is Martha Koome in hitting that reset button?
Well, she's got a huge responsibility. And starting from where Nyaribo has left, I've watched when judges, the other day, Suluhu Hassan appointed judges, when they were taking oath of office, they went before her, and there was that bending gesture. It occurs in the UK, it occurs everywhere. Yes. That's simply a sign of respect to the president or head of state as a symbol of national unity. It's got nothing to do with personalities. So if you look at that symbol, that optic, and then claim that you are beginning on the wrong path, that is really voodoo logic. The second thing...
We have to wind up.
Yeah, she's the only person who had, when being interviewed, had a strategic plan. She presented the strategic plan, and the Judicial Service Commission said, this is a good idea. Now she had a huge burden. Do I stick with the Maraga principle, none or all, or I get judges to work on this backlog? For Morai Nkisi, who has got land matters, for Morai Nkisi, who has got environmental issues, and then you tell her, I'm running with the Maraga principle, and yet she's suffering a lot of, peculiar embarrassment.
Early days it is.
It's very early in the day for foreign books from an opinion. All
right. We really have to leave it there, gentlemen. Many thanks for your time. Apologies, we had a shorter show today because of course, the Eldoret City Marathon. Dismas Mokua, political risk analyst, governance expert, Charles Kipkulei, lawyer, and political analyst Ishmael Nyaribo, as well as joining us all the way from Zanzibar, lawyer and political strategist Kipchumba Karori. Many thanks. Be sure to join us every Sunday. We do this usually from 11 a.m. to 1 p.m. here on KTN News. I'm Ben Kitili. Don't go anywhere. KTN Weekend at 1 is up next with George Marine.